would use in addressing those 4 issues. And the first issue was the burden of proof. On that question, the court stated as follows: it is satisfied that the petitioner, that it follows that once the court is satisfied that the petitioner has adduced sufficient evidence to warrant impugning an election, if not controverted, then the evidentiary burden shifts to the respondent, in most cases the electoral body, to adduce evidence rebutting that assertion and demonstrating that there was compliance with the law, or if the ground is one of irregularities, that did not affect the results of the election. In other words, while the petitioner bears an evidentiary burden to adduce factual evidence to prove his or allegations of breach, then the burden shifts and it behoves the respondent to adduce evidence to prove compliance with the law. We shall revisit the issue of shifting of the burden later in this judgment. On the standard of proof, the court determined as follows. We maintain that in electoral disputes, the standard of proof remains higher in the balance of probabilities, but lower than beyond reasonable doubt. And where allegations of criminal or quasi-criminal nature are made, it is proof beyond reasonable doubt. Consequently, we dismiss the petitioner's submissions that the court should reconsider the now established legal principle as discussed in the judgment and find that the standard of proof in election petitions is on a balance of probabilities. We recognize that some have criticized this higher standard of proof as unreasonable. But as we have stated in the judgment, electoral disputes are not ordinary civil proceedings, hence reference to them as sui generis. It must be ascertainable based on the evidence on record that the allegations made are more probable to have occurred than not. The third question which we had to address was rejected votes in a presidential election petition in Kenya. Having addressed the submissions by parties, the court noted as follows. In these circumstances, we cannot see how a rejected vote, a vote which is void, a vote that accords no advantage to any candidate, can be used in the computation of determining the threshold of 50% plus 1. In our view, a purposive interpretation of Article 138(4) of the Constitution in terms of Article 259 of the Constitution leads to only one logical conclusion, that the phrase votes cast in Article 138(4) means valid votes. Consequently, we maintain this court's view in the 2013 Raila Odinga case and accordingly reject the petition's invitation to reverse it. The fourth issue of law which we had to address was the meaning of Section 83 of the Elections Act. Having interrogated that section, the court determined as follows. Having analyzed the wording of Section 83 of the Elections Act, bearing in mind its legislative history in Kenya and genesis from the Ballot Act of the UK, and also in light of the need to keep in tune with Kenya's transformative constitution, it is clear to us that the correct interpretation of the section is one that ensures that elections are a true reflection of the will of the people of Kenya. Such an election must be one that meets the constitutional standards. An election such as the one at hand has to be, therefore, both quantitatively and qualitatively in accordance with the Constitution. It is one where the winner of the contest obtains more than half of all the votes cast in the election and at least 25% of the votes cast in each of more than half of the counties under Article 138(4) of the Constitution. In addition, the election which gives rise to this result must be held in accordance with the principles of free and fair elections, which are by secret ballot, free from intimidation, improper influence, or corruption, and administered by an independent body in an impartial, neutral, efficient, accurate, and accountable manner under Article 81 of the Constitution. Besides the principles in the Constitution, which I've enumerated above, that govern elections, Section 83 of the Constitution of the Elections Act requires that elections be conducted in accordance with the principles laid down in that written law. The most important written law is, of course, the Elections Act. But that is not all. Under Article 86 of the Constitution, IEBC is obliged to ensure inter alia, and we quote, whatever voting method is used, the system is simple, accurate, verifiable, secure, accountable, and transparent. The votes cast are counted, tabulated, and the results announced promptly by the presiding officer at each polling station. The results from the polling station are then openly and accurately collated and promptly announced by the returning officer, and appropriate structures and mechanisms to eliminate electoral malpractice are put in place, including the safekeeping of election materials. That is a standard we shall use in analyzing the issues for determination. And therefore, with the above imperative constitutional legal principles in mind, we now like to turn to the facts of the case, starting with the first limb of Section 83, and in this, we shall be analyzing the violations of the principles in the Constitution and the electoral law that the petitioners are complaining of.
We are answering the question whether the 2017 presidential election was conducted in accordance with the principles laid down in the Constitution and the written law relating to elections. In paragraphs 12 and 13 of the petition